Hey everybody, welcome back to Chalk and Gavel. Thank you so much for giving us your time. We really can't thank you enough for joining us as we get this podcast off the ground. So, in order for us to make this podcast reach a wider audience, we really need your help in liking, rating, reviewing, following us. We've heard that doing that really gets this podcast out in front of a wider audience. So please take a few seconds and do that, and go to chalkandgavel.com as well to tell us what you think about the show. We've got a feedback form up on our website, and we would love to hear what you think, what we're doing well, what you think we can improve on. We really want to make Chalk and Gavel the best that it can be. And go ahead and connect with us on social media as well. Our handle is @ChalkandGavel. We would love to hear what you think. You can give us topics for the show if you've got cases that you think we need to cover, if you've got guests you think that we should have on the show, if you've got an idea for a bell ringer, don't hesitate to let us know. We would love to have your feedback and get your voices represented on the show. So, without further ado, let's get to today's show.
Where's the line between parental rights and a district's authority over the curriculum? Between permissible influence and impermissible indoctrination? What rights do parents have to opt out of instruction they don't agree with? How do we balance the values of individuals with the outcomes of larger democratic processes? How long do you often go before you do a complete 180 and change your decisions?
It depends on how long my kid has been crying and telling me that I'm not fair.
Kids have such a finely developed sense of justice. It is one of my favorite things about my toddler right now. He said that's not fair for like one of the first times the other week.
Yeah.
We had a wonderful conversation about fairness and justice.
Are you really happy you got your law degree now that you have children? Or has it not helped?
It's a little harder to reason with them.
See, even lawyers. All right, stay tuned as we travel north to Maryland to explore the recent 2023 ruling in Mahmoud versus McKnight, a very recent and relevant case at the heart of the messy intersection between parental rights, family and societal values, and the school curriculum.
Hello, everyone, and welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas, a former teacher and school attorney.
And I'm Jamie Cudlitz, a former teacher and middle school principal.
Now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right. So, Jamie, what's our bell ringer for this week?
Okay. For this week, I wanted to mention an article that recently came out from EdWeek. It was a January 31st article written by Ariana Prothero. And interestingly enough, I've been wanting to mention this particular issue, this case, for a while now, but we didn't see this one coming. But this article that came out features our one and only Dr. Chris Thomas was quoted in this particular article. That's not why we're talking about this as our bell ringer today, but it's a nice coincidence.
It is.
Yeah.
I mean, it could be why we're talking about it.
Well,
it was pretty fun.
Yeah. So it's an interesting case. You may have heard about this in the news. It started out in Seattle, but it's picking up a lot of steam now. So there's a number of school districts that are suing the major social media companies. Okay. You probably heard this one. It started with the Seattle district, and now like we've got over 200 school districts. It's still in the early stages, and it's kind of similar to that Juul e-cigarette thing that, came up a while ago. They're talking about how what the schools are seeing right now is such an increase in anxiety and depression and mental health concerns that are largely stemming from their social media usage. And it's really complicating schools' efforts to combat mental health issues and all of that stuff. And so the lawsuit is about how these social media companies design these algorithms to target kids, to manipulate them. And so, one of the things that's really interesting about this potential legal case is that there's a lot of differing opinions right now as to how successful this case could be from a legal perspective, right?
And how to measure success, right?
Yeah. And so one of the things that you mentioned in the article, Chris, which is, something that I had talked to some of my classes about, is that this may not be as much about winning in the court as it is about gaining a lot of traction in the court of public opinion.
Right.
Right?
Yeah, no, I think that's a huge part of the strategy here.
Yeah.
So these cases are bringing a kind of a public nuisance claim, which is the cause of action that they're bringing. And we've seen folks bring public nuisance claims for some really big kind of like societal issues. There's big litigation around cigarettes. That was a public nuisance claim. A bunch of states brought that because of the burden on the healthcare system that cigarettes were causing. You mentioned the e-cigarette thing with Juul.
Yeah.
There's lots of different situations where we've seen government actors bring these claims, and typically they come about because the people who are impacted by these different issues are kind of having to go it alone because other folks haven't stepped in to really deal with these situations that they're grappling with.
Right.
And so, here we've got this school district bringing this lawsuit, and whether they're going to succeed on the merits or not, right now, the big thing is just how it's shaping the conversation and how it's forcing us to grapple with the impact that social media is having on this generation of students.
Yeah. So to your point about how do we define success here? We could consider a potentially very successful outcome without, say, for example, these school districts officially winning the case, right?
Right.
Change can happen as a result of this without the school districts winning the case.
Right. This is a massive lever, or let's call it a motivation, to kind of get change, because we've already seen lawmakers kind of pick up on these issues and start to really kind of push social media companies and kind of challenge them on their responsibility, perhaps, or how they contribute to children's mental well-being. And some states have really started to make some laws. So Florida right now is considering a law that would essentially forbid social media companies from giving accounts to anybody under 16 years of age, which, I don't know if that's the right way to handle it, but it's definitely some serious action, right?
Right. Well, and how something like that could potentially play out in practice, it remains to be seen, because half of these, maybe not half, but probably most, if not all of these social media companies restrict account opening by age already. But that, does that actually happen?
I mean, we were both classroom teachers. You were a principal.
They don't work very hard. They say you can't open an account if you're under 13 or something like that. But it's as simple as type in your birth date and click this box to tell us that you're over 13.
Well, and that's what a lot of these laws are doing. Folks have been kind of legislating these issues for a while now.
Yeah.
And some of the early adopters have required state issued IDs through authentication sites. It can get pretty serious. And then that raises a whole host of privacy concerns as well. So it's not just a question of who should be controlling children's social media use. Because to me, I think that there's a potential parental rights issue here too. If the state just says no kid under 16, not only does that kind of probably infringe on the child's speech and their ability to kind of be like engage in this like robust marketplace of ideas, but like parental rights too. Like, what if I want to allow my kid to have a social media? I don't know. It's a really complicated situation. The technology piece is just another layer on top of it.
Yeah, exactly. So, I mean, listen, this is going to be a really interesting case to follow, regardless of the official outcome here.
Right.
There's, the fact that we keep getting more and more school districts signing onto this thing is going to make it pretty public.
And the more stories we hear about how school districts are having to navigate just the incredible challenges of student well-being right now.
Exactly. All right. Well, as we have done and as we will continue to do, we will report back on any major changes and evolutions with this case and anything else that we think is relevant to all of you educators and those interested in education listening to this podcast. Okay. You ready to talk about today's case?
I was born ready.
All right. Well, let's talk a little bit about Mahmoud versus McKnight. Okay. So we're going way back to 2023 with today's case. This is a case about parents who objected to certain curricular materials that included LGBTQ-inclusive texts. Okay. So we're up in Maryland in Montgomery County, the Montgomery County School District with this case. It's the largest public school system in Maryland and one of the largest in the country. So as of fall 2021, Montgomery County School District included 209 schools with approximately 160,000 students.
Whoa.
So I want to give you, before we jump into some of the facts of this particular case, I want to give you a little bit of background about the district and some of its priorities because they're very, very relevant to this case. All right. So the school board in Montgomery County has a stated belief that diversity in its community is an asset that makes it stronger and that building relationships with its diverse community requires it to understand the perspectives and experiences of others. As such, the board has a policy on non-discrimination, equity, and cultural proficiency, which supports, quote, proactive steps to identify and redress implicit biases and structural and institutional barriers that too often have resulted in disproportionate exclusion and underrepresentation.
Right? Okay. Yeah, and I imagine a lot of schools have
very similar
policies.
Yeah.
They might not be worded in the same way, but a lot of school districts probably have a policy that is very much a similar expression of values.
Exactly. So the school board, to that end, strives to provide a culturally responsive curriculum that promotes equity, respect, and civility, and prepares students to confront and eliminate stereotypes related to individuals' actual or perceived characteristics, including gender identity and sexual orientation. A critical part of the school board's approach is representation of diverse identities and communities in the curriculum. The board said, quote, representation in the curriculum creates and normalizes a fully inclusive environment for all students and supports a student's ability to empathize, connect, and collaborate with diverse peers and encourages respect for all.
Nice.
Yeah, so that's kind of like the board, like you said, has some very clear values around adequately representing the diversity that exists within its community, adequately representing that within its schools. Okay.
Yeah. And what I really appreciate about this policy and kind of how the board's approaching it is like, not only does it ensure that everyone feels recognized or is able to kind of see themselves in the curriculum, which can, like that's huge for building kind of these deep relationships between teachers and schools and children that we really want to cultivate. But it's also, they phrase it as beneficial to everyone. So it's not just about everyone feeling seen and respected, but it's also about kind of helping everyone
connect and empathize
right. And be able to kind of like understand or
collaborate.
Collaborate. Connect, collaborate, and listen.
Was that just Ice Ice Baby? Did you just quote?
Yeah, I did. You did.
Did I? No, I didn't say listen.
Maybe I did.
I think that was
I
you.
added that. Yeah.
Vanilla Ice, ladies and gentlemen.
Who thought he'd make an appearance today?
Oh boy. But yeah, and on top of that, like, you know, you said how important it is for kids to, you know, to see themselves represented in the curriculum. And I think there's plenty of evidence out there, you know, as well, that talks about how important that is, because we always talk about how can we make learning more relevant for kids, right? And the reason is because if you can't relate to what you're learning about, if you can't see yourself in what you're learning about, it makes it harder to learn about those things. Right?
Yeah. And it's how we show individuals respect too, right? Like,
right. So there's a lot of different angles here. You know, a lot of potential benefit from this kind of approach.
Yeah. And it helps other kids see, you know, walk a mile into someone else's shoes and to kind of figure out how to interact with people that are different than them in our, you know, incredibly diverse, pluralistic society.
Right. Yeah. And so at issue in this particular case is how the board decided to go about operationalizing, so to speak, that set of values. Okay. So what they did was they decided to review existing curricular books and determined during that review, they determined that the books in its English language arts curriculum were not sufficiently representative because they didn't include LGBTQ characters. Okay. So this all took place in the spring of 2022. So the board decided that it would evaluate the, you know, potential new materials so that they could have more inclusive texts. So they did what we love to do in schools, and they formed a committee. We love committees in schools. And on this committee were 4 reading specialists and 2 instructional specialists.
Okay.
And they ended up recommending a number of new books because they supported the district's standards and performance indicators, contained narratives and illustrations that would be accessible and engaging to students, and featured characters of diverse backgrounds whose stories and families students could relate to. Okay?
Okay.
That was what the committee said was the reasoning behind an adoption of a total of 22 new books.
Okay.
Okay. And those books, I believe, were sort of officially adopted in October of 2022.
Okay.
Okay.
And now, like, a big part of the story is how the school or the district went about, like, the adoption process and the implementation process of kind of putting these books in teachers' hands, and then what they did with them.
Exactly. There was a lot that happened, right, between the spring of 2022 and October of 2022 when they officially adopted these books.
Right. And then between October 2022 and this lawsuit, right?
Right, exactly.
So that the forming a committee, like, I know we joked about committees, but I think it's really interesting who's on that committee. So it's just district folks, reading specialists, and instructional specialists who are evaluating these texts for, one, kind of to see if they're representative of diverse backgrounds and families and folks that students can relate to, but then also just kind of seeing if they meet kind of academic standards.
Right.
And so, you know, having just district personnel on the committee, one of the things that's going to come up is like this idea of, well, what voice should the community have had in the adoption or in kind of the implementation of these reading materials?
Well, and when you say community, we're not just talking about parents, right? We're talking about principals, teachers.
Sure.
You know, like, yeah. So like you said, you know, there were 6 district personnel
who are focused exclusively on kind of the educational merits of these things. And so, you know, that's kind of an explicit choice by the district to not include those other stakeholders. But I think that also goes to the district's like priority here, which is we are trying to find educationally appropriate materials that fill a gap that we notice in representation.
Yeah. Now, before we kind of get ahead of ourselves here, it's really important to note, how the district handles these kinds of curricular materials, right? And the expectations that the district lays out for schools. So there's no specific requirements on the use of particular texts in the district. Okay. Teachers can decide how they will use the texts to meet district objectives. The district only suggested that teachers incorporate the books into the curriculum like they would any other book. And they basically said, quote, namely, to put them on a shelf for students to find on their own, to recommend a book to a student who might enjoy it, to offer the books as an option for literature circles, book clubs, or paired reading groups, or to use them as a read aloud. So the district is not mandating that these books be used. They're not mandating that they be used in a certain way. They're just putting them out there for teachers to sort of use their discretion. Okay?
Yeah.
And while the board expects, quote, that teachers use the LGBTQ-inclusive books as part of instruction, unquote, as with all curriculum resources, teachers have a choice regarding which approved materials to use and when to use them through each unit, and may choose among the texts rather than being limited to a single book corresponding to a grade level. So again, lots of choice and discretion here.
Right. So basically, the district has these curricular materials that kind of get the stamp of approval, and then teachers can go within those approved curriculum materials to kind of use them as they see fit.
Yeah.
Okay.
Now, the board also said there was no planned explicit instruction on gender identity and sexual orientation in elementary school, and that no student or adult is asked to change how they feel about those issues. Rather, the books will be used to assist students with mastering reading concepts like answering questions about characters, retelling key events, and drawing inferences about story characters based on their actions. So very standard kinds of curricular objectives, learning objectives, right?
Right. And that tends to be one of the biggest kind of objections to curriculum like this, is this idea that these young children shouldn't be exposed to kind of instruction related to gender identity or sexual orientation, just because, that might not be something they're mature enough for. And, I think the district handled that really well by saying kind of like, we're not, just because these characters are in these stories, we're not teaching
not the goal.
About those topics. We're using these representative texts, or these texts that include diverse representation, to teach the things we would always teach, like literacy, reading skills, reading comprehension.
Right. But it allows the students, according to the district, it allows the students to see more of a diverse culture, right?
Right.
Within that sort of curricular framework, right?
Right. Right. And you got to imagine that the books that existed before they added these 22, like, they were probably not completely devoid of opposite sex couples, right? Like opposite sex families, or, heteronormative ideas, right? Like, so in a way, this kind of like including these diverse family structures kind of corrects an imbalance.
Right. So even though the district said, that this is about mastering reading and retelling key events and drawing inferences and things like that, the district still offered professional development to teachers to give them a little bit of guidance on how to basically respond to potential community concerns with respect to these books. So there were documents and instructional materials that were provided, thoughts and suggestions for responding to student questions, how to respond to community questions and feedback and things like that. And it looks like that guidance and professional development took place before the 2022-2023 school year started, probably in August. But again, the books weren't officially adopted until October.
Yeah. And I think that's such a great approach to this rollout, when the school board kind of knows that they're probably wading into some tricky political waters.
Yeah.
And so to really kind of empower their teachers to so that it doesn't fall on the teachers to kind of, take the brunt of this, or to not feel prepared to engage in those larger conversations. Like, I think this PD, and we don't know kind of how systematic that was and how many teachers took advantage of it and how long it was and those sorts of things. But like, to be proactive in that way, I think is really, really beneficial.
I agree. But at the same time, in light of what you said earlier, it's almost like the district was choosing to be proactive with just a particular group, with its teachers. It doesn't sound like, or at least from the information we have about this lawsuit, that there was any sort of engagement of the broader community before the rollout of these books. Listen, maybe that was a deliberate choice on their part, but again, like, it's just something interesting to think about. I'm definitely not advocating to say, like, you've got to open these kinds of discussions up every single time you have them because, if we did that, we'd get nothing done.
Oh, so it'd be like a committee?
Yeah, exactly. And on top of that, like, there is something important about, the educators in many respects are the experts on the curriculum and pedagogy and things like that. But again, this is a very sensitive and big kind of topic right now, going around, a big conversation about the degree of involvement.
Right.
Well,
and these library books, these books as part of the curriculum were adopted by the school board. And so that means that they had to have been adopted by some official action of the school board. And I imagine, they would have to do that at a public meeting with the potential for community input or, whatever kind of the state laws require for school board action. So like this is something that the community, at least at that decision point, maybe that's not the implementation, but they definitely were involved at that point and had opportunities to have their voices heard.
Right.
And the school board, probably locally elected, all that stuff. So there's another opportunity for them to kind of have their voices heard in those elections.
Sure. No, totally. Well, let's keep going and talk about, what happened sort of in the months leading up to the lawsuit, because it gets kind of interesting here. And these, the things that we're going to be talking about are, I think this kind of stuff is going to resonate with a lot of folks, a lot of listeners, because this is sort of a hot topic everywhere. All right. So in November, so remember the books were adopted in October. In November, there was a white paper created by the Montgomery County Association of Administrators and Principals that expressed concern about these books, saying things like, several of the books and supporting documents seemingly contradict the message that the books were not supposed to be teaching about sexual orientation or gender identity as standalone concepts in elementary school.
Okay.
By giving teachers discretion on what to incorporate and how, it's putting them in a tough spot with such potentially controversial material, concerns about age appropriateness, objectivity, things like that. Right. So this was a white paper from the Association of Administrators and Principals that was expressing concern about this.
And their concerns seem to be kind of procedural in nature, or like basically saying, in a way, they're kind of looking out for their teachers. Like,
well, yeah, I'm going to editorialize a little bit here. I'm all about teachers having autonomy in what is used to meet curriculum goals and objectives and how to use those things. Every classroom is different.
Right.
Teachers are professionals, in most cases with lots of training and experience. Okay? Expecting teachers to teach cookie cutter lessons and read from scripts is a great way to standardize, but a terrible way to teach.
Oh, absolutely.
Right? And, but that said, the stuff in question here is often very controversial. It's very polarizing, and it can require a lot of dexterity to appropriately thread these instructional materials and concepts through the proverbial curriculum needle.
Right. And confidence too, right?
Right. This is hard. So, in the complex, emotionally charged, under the microscope context in which today's teachers and schools exist, there's a lot of pressure for teachers and administrators who are already getting dumped on with mandate after mandate, who are already being told to work academic miracles with fewer and fewer resources, and who are often the first to be criticized when something doesn't go right, right?
Unless it's like that 2-month window right when the pandemic started.
Oh, yeah. Yeah.
That was
then you got
a
a little grace period, right? Yeah. So, I guess all I'm saying is that we want teachers to use their training and expertise to have some autonomy. But whoever, our society, our policymakers, whatever, they don't give them the support, the deference, the space.
Mm-hmm.
They don't value them. They don't give them the resources, whatever, that they need to exercise that expertise. So expecting the average teacher to use their discretion to navigate something like this,
right,
that is so complex with everything else that they're expected to navigate. I think that the phrase that the white paper used, something about putting teachers in a potentially polarizing position, is like putting it mildly.
Sure.
Right?
Yeah.
So
good alliteration.
Yeah, potentially polarizing position. I don't know if that was intentional or not, but anyway.
It doesn't make for good podcast audio.
No.
We'll get the plosives out of there.
It doesn't. Okay.
But yeah, so you can definitely see where the principals have concern, right?
Yeah.
We want our teachers to feel confident and comfortable in, using these materials and not feel afraid or unprepared. Maybe that's a better way to say it, unprepared for the potential political situation that they're wading into.
Yeah.
And so that's why I think that rollout of professional development and support is so important and crucial. And the principals here are kind of saying it doesn't seem like they disagree with the direction the board is going or why the board's doing it. Maybe they just kind of disagree on how they're doing it.
Yeah.
Or the extent to which they're supporting their teachers in doing it.
Yeah. And so, one example that this white paper used, right? They were questioning whether or not some of the material was age appropriate. So the white paper referenced one of the adopted books, and one of those books was called Love, Violet. And that book is about a shy kid's efforts to connect with her crush on Valentine's Day.
Mm-hmm.
And that crush just happens to be of the same sex. Okay?
Mm-hmm.
And so the white paper referenced that book and said, it is problematic to portray elementary school age children falling in love with other children, regardless of the sexual preference. And so, I only give that example to sort of illustrate how complex this is, right? I mean, I think that there are probably people out there listening who say, listen, I've got no problem with LGBTQ inclusive texts. I've got no problem with those kinds of relationships and, blah, blah, blah. But maybe I agree that I don't care, who's falling in love with whom, but I don't want to see that in elementary school. And so it's not such a black and white, one side or the other. There's nuance here, right?
Oh, absolutely. But I think that kind of the flip side of that question is did they go through all of the books to make sure, if that's a concern that they have, did they go through all of the books to make sure that there's not examples of
the other?
Yeah, of opposite sex.
Exactly.
Right.
Which is a really important question.
Right.
All right. So between November 2022 and March 2023, there were a bunch of questions raised about opt-out policies. Okay. So that's kind of at the heart of this case, is these opt-out policies. The state has an opt-out policy sort of requirement for things like health education, sex education, those kinds of things. In addition to that, the district also allowed for sort of limited opt-out opportunities based on religious objections and things like that. So that's kind of what is at the heart of this case.
Mm-hmm.
All right. So the parents in this particular case contend that these opt-out policies would apply to the storybooks for these, these LGBTQ inclusive storybooks, because in their view, those books concern family life and human sexuality. And the school board's position was that the storybooks are part of its English language arts curriculum. And since opt-outs do not apply to that curriculum, because it's only for the family life and human sexuality units of instruction, which is a different curriculum, the policy does not apply here. So I think this is a good time. Let's tell our listeners about the 7 books that the parents objected to.
Right. Or at least the ones they specifically listed in their complaint.
Right. So remember, there were 22 books that were adopted, but the books that were listed in this complaint were 7, and here they are. So one was called Pride Puppy, and it's about a family's visit to a Pride Day parade and their search for a runaway puppy using the letters of the alphabet to illustrate what a child might see at a pride parade. Okay. Another book, Uncle Bobby's Wedding, tells the story of a girl who is worried that her soon-to-be married uncle will not spend time with her anymore, but her uncle's boyfriend befriends her and wins her trust. Next was Intersection Allies. We Make Room for All. This book features characters who describe themselves and their diverse backgrounds, connecting each person's story to a struggle for justice. The book My Rainbow tells the story of a mother who creates a rainbow-colored wig for her transgender child. The book Prince and Knight is about a young prince who falls in love with and marries a male knight after they work together to battle a dragon. The book Love Violet, which we mentioned earlier, is about a shy kid's efforts to connect with her crush on Valentine's Day, and that crush happens to be of the same sex. And then there is a book called Born Ready, the true story of a boy named Penelope. And that book is about a young kid who experiences ups and downs as he works to convince others what he knows to be true, that he is a boy and not a girl. The first one, Pride Puppy, that one is listed for pre-K and the Head Start program, and the rest of the books were labeled kindergarten through 5th grade. Okay.
Some adorable sounding books.
Yeah. So between November and March, there were a lot of opt-out requests. There were also tons of school board meetings where this issue was continually brought up.
Sure.
There were so many opt-out requests that during a March 2023 meeting of principals, it was mentioned that they just simply could not accommodate so many requests. They just wouldn't be able to teach.
Right, which totally makes sense. Like, you can't have, every student that opts out needs some sort of alternative curriculum, especially if you're opting out a bunch,
Yes,
right? Like, so
exactly.
And that's one of the things that, like, the practical implications of opting students out of particular parts of the curriculum is like,
right. It's not that easy. What are you going to do with them?
Logistically, yeah. And teachers have to plan a second lesson, like, especially if you have lots of kids opting out for lots of different reasons.
Yeah.
Just the practicality of it.
Yeah. Logistically, it's a nightmare.
And I think that was part of the district's policy for religious opt-outs. It essentially said, like, we allow religious opt-outs to a reasonable degree, but, like, we're not going to redo the curriculum. And if it gets too much, then we aren't going to allow them. I think that, that's kind of the gist of the policy.
Yeah, exactly. And so here's where it gets kind of fun. Okay, so you mentioned at the top of the episode, how quickly can you do a 180? Well, let's find out how quickly the board does a 180. So on March 22nd, district spokesperson responding to a media inquiry issued a statement confirming parents' notification and opt-out rights. When a teacher selects a curriculum, a notification goes out to parents about the book. If a parent chooses to opt out, a teacher can find a substitute text for that student that supports these standards and aligns with the curriculum.
What's interesting about that, though, is it requires the teacher to send out a notification. So it's kind of proactive, which, it's kind of weird because it requires, I wonder if they do that for every piece of curriculum or if they do it just for these 22 books. Because, like, when you're a teacher, like, I've got friends who are English teachers, requiring them to kind of be proactive and say, like, here's what we're going to learn. And then, like, to navigate those opt-outs, like, that's a huge burden on these teachers.
Right. And if there's a book that talks about a kid navigating their crush that they have on somebody who happens to be an opposite sex child, are they sending a potential opt-out notification or whatever for that?
Right. Yeah. So is there consistency in the policy?
Exactly. So that was on March 22nd. Okay. So this media inquiry, and the board basically said, hey, this is our opt-out policy. The next day, on March 23rd, so the answer to that question from the top of the episode is, how long does it take to do a 180? 1 day.
Less than 24 hours.
Less than 24 hours. The school board reversed course and issued a revised message regarding the use of inclusive texts. And that message said that there is an expectation that teachers utilize these inclusive lessons and texts with all students. Students and families may not choose to opt out of engaging with any instructional materials other than Family Life and Human Sexuality Unit of Instruction, which is specifically permitted by Maryland law. As such, teachers will not send home letters to inform families when inclusive books are read in the future.
Okay.
Yeah.
So that answers some of those questions. It sounds like it was just notifications when the inclusive books were being,
Exactly.
which is itself, potentially problematic, I think.
Yeah.
Yeah. 24 hours and the district does a complete 180 from we're going to keep notifying you and allow you to opt out versus we're not going to notify you anymore and you can't opt out.
This is a part of our English language arts curriculum, and we don't have an opt-out policy for that.
Right. So the district doesn't seem like they did themselves any favors by putting this statement out on the 22nd and then on the 23rd coming back and being like, oh, wait a second, you know what? No, thank you.
Exactly. So
Probably not a lot of community or stakeholder input between those two things.
not between those two things, but there was plenty of community input at school board meetings, essentially between November and then the summer of 2023 when everything turned into a lawsuit.
Sure.
So the school board meetings had lots of comments made, both in support of the board's decisions and against. And board members responded to those various concerns in different ways, but they were largely in support of its policies. Okay, which makes sense. It would likely be an understatement, however, to say that this was a hot topic in the community.
I can imagine.
So
yeah, a lot of community trust
Yeah.
concerns here. too.
Exactly. And so let's really quickly talk about the parents who were bringing this lawsuit.
Mhm.
The parents in question here, they're of diverse faiths. One of them was a Muslim family, one a Roman Catholic and Ukrainian Orthodox family, and the other one was a Catholic family.
Okay.
Their kids were all in the elementary schools in Montgomery County. And it was noted in the court records that each believes that all persons should be respected regardless of sex, gender identity, sexual orientation, or other characteristics. However, each also has religious objections to the storybooks. So the court report goes into some good detail about each family's faith and beliefs, according to the declarations that were made by each family. But for the sake of time, I think we'll just skip most of that detail. But the long and the short of it is that the families don't really agree with many of the beliefs, ideals, or stances regarding LGBTQ issues, and largely feel that schools should not promote or even include such stances in the curriculum. They either just don't agree with it and feel that it doesn't belong in school, it goes far beyond promoting respect, or that it undermines their ability to raise their kids according to their family's beliefs. So that's sort of the family's position in a nutshell.
Mhm. Right. And yeah, so the claim here or their concerns seem to be that like by having this curriculum in schools, you're kind of undermining our ability to raise our children the way we want to raise them within our religious beliefs and traditions, which,
Yeah.
may go against what these books or what they see these books as promoting. And so, it becomes this kind of, concern of parental rights. So like to what extent do parents have the authority to kind of raise their children as they see fit, as well as kind of this question of familial relationships. Like if religion is really important to our family, if it's something that we all have in common that binds us together, that we all share, like if you are teaching different beliefs or values, that could drive a wedge or that could like undermine those relationships.
Right.
So you can definitely see the concerns that these folks are raising.
Yeah, absolutely. Okay. So this is basically the whole setup for the lawsuit. So what happens next, Chris?
Well, the parents bring a lawsuit.
Oh boy.
I know, right? So, all of that happened in March, right?
Yeah. I mean, like between November and March, everything looks like everything got really heated in March.
Right. So let's call it reversal.
Yeah.
On March 23rd. Like, I think that's the straw that breaks the camel's back here because about 2 months later, you get a lawsuit that gets filed on May 24th. So yeah, like what, exactly 2 months later?
Yeah. And it probably takes about that long to kind of
hire a lawyer, get somebody to write it up.
Rally the troops, right?
Yeah. Actually, 2 months is really fast. I'm actually that's quick.
Maybe they were working on it, maybe like the Kennedy case.
They had it in the back pocket. Yeah. So, the high level here is we've got these parents on behalf of themselves and on behalf of their children kind of filing this lawsuit in federal court, bringing some First Amendment claims related to the free exercise of religion and free speech, as well as some substantive due process claims based on 14th Amendment rights to direct the upbringing and care of your children. And so those are kind of the big constitutional claims. We've also got some claims here based on Maryland law, but the court doesn't really get into that because it just addresses the federal claims.
All right. So one of the things that's really interesting to me here, Chris, is that some of the claims that these families are bringing up, with respect to the First Amendment free exercise clause and the 14th Amendment parental rights to direct the upbringing of their kids claim, is that we've seen a lot of these kinds of arguments in cases for, the better part of 100 years in education, right? But one of the interesting things is, and I'm not saying that this case is going to get to the Supreme Court, but the Supreme Court has given a lot, when we talked about it in Kennedy, has given a lot more deference to the free exercise clause of the First Amendment over the Establishment Clause, right?
And other constitutional provisions, like the free exercise clause or freedom of religion seems to be taking kind of precedence over a lot of other potential constitutional concerns.
Yeah, exactly. And then on top of that, this due process clause, this piece of the 14th Amendment that talks about parental rights to direct the upbringing and care of their children. Like we've seen cases in education off and on for 100+ years that where parents have raised those concerns, whether it's with respect to discipline or whatever, or influence over the curriculum. And courts have generally been, have sided a little bit more with the schools on a lot of those claims. So
they've been much more deferential to schools.
Yeah, but there's a lot of this stuff, as we talked about sort of off the air, as you mentioned, there's a lot of these cases percolating now, right? Obviously.
Right. Yeah. We're kind of in the middle of a new parental rights movement where a lot of people are making claims about parental authority related to education and related to the education of their children. And so lots of families and groups and politicians right now are talking about parental rights and using that to justify a lot of different kinds of policies. And so, this case kind of exists at the confluence of two really important trends right now.
Yeah.
We've got kind of this reshifting of religious jurisprudence with the Supreme Court's recent decisions and things like Kennedy and Carson versus Macon. And then, you've got this parental rights movement, which is kind of promoting the idea that parents should have more authority over education. And here we've got this case that is kind of like the perfect intersection of the two.
Right. Which is why we picked it.
Hey.
All right.
Look at that.
All right. Well, let's keep going.
Yeah. So they filed this case on May 24th, and on June 12th, so very quickly after that, they file for a preliminary injunction. And
well said.
Hey, it didn't take 10 minutes of takes this time. Look at me, I'm getting better. So the preliminary injunction, essentially what they're trying to do here is they're making a motion to the court to basically maintain the status quo and to prevent what they allege would be irreparable harm during the pendency of the lawsuit. So while the lawsuit is going on.
Yeah.
So essentially, to get a preliminary injunction in a situation like this that involves constitutional claims, it all comes down to, do you have a likelihood of success on the merits? And so that's kind of the ultimate question that the court here is trying to answer is, do they have a likelihood of success on their free exercise claim and their parental rights claim? And so looking at those two claims, the court kind of looks at them and says, you know what? I don't think you have a chance of success on either of these claims. So I'm going to deny your motion for a preliminary injunction. And, that's kind of a big deal because it allows the district to move forward with their no opt-out policy.
Yeah, exactly.
So looking at the claims for the free exercise claim, and I'm really glad that we did Kennedy because we're all experts on the free exercise clause now.
I know, right?
So under the First Amendment, it has a clause that says Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. And so this essentially protects against laws that either discriminate against or among religious beliefs or that restricts certain practices because of their religious conduct. And so that's kind of what the free exercise clause is trying to prevent. So to constitute a violation of the free exercise clause, the government policy has to burden religious expression. And that's going to be really, really important for this case.
Yeah.
It has to burden religious expression, meaning that it forbids or hinders unrestrained religious practice or worship. The government is coercing or pressuring you to either do or to forego or to modify your religious practices or beliefs.
Right.
Yeah. So the court is looking at whether or not there was a burden here. And
they said no.
They say no.
Yeah.
Right? this is not burdening your religious expression. So we're not even going to trigger the free exercise clause. So we don't even have to analyze whether or not this potential violation gets strict scrutiny or rational basis or anything like that, because we're not even going to get to step 2 because you don't get past step 1. And so,
well, because they were, basically what was happening here was you're exposing kids to a bunch of ideas. And
right,
because you don't agree with some of those ideas, that's not necessarily a burden.
Right. And the court says to that exact point, here's a direct quote from the court. They say, mere exposure to ideas in public school did not burden religious exercise because students were not required to behave contrary to their faiths or affirm any views contrary to their religious beliefs. And 2, parents were not prevented from discussing and contextualizing any contrary views at home.
Yeah.
So it goes back to something we've talked about before, where like the antidote to speech is more speech, and it doesn't tell you what to believe. It just,
it gives you a lot of information, and it says you could do whatever you want to with this information. But this information exists.
Right. Yeah. The difference between exposure and indoctrination, right?
Right.
Yeah. And the court, they say they're on very firm grounds here because they say that every court who has addressed the question about whether or not exposure to ideas in public schools that contradict religious beliefs has found that exposure does not burden religious exercise. So they cite cases from the First Circuit, the Sixth Circuit, the Seventh Circuit, the Ninth Circuit, and the 10th Circuit that all kind of come to that conclusion. Wow. So a lot of courts seem to agree that just like mere exposure to these ideas does not constitute a burden of
your free exercise,
your religious freedoms.
Yeah.
Yeah. And they go on to say that like, there is a difference here between exposure and indoctrination, and there's a line that can get crossed, but here it doesn't cross that line, because when we get closer to that line, that's when there's something more than exposure at play here.
Yeah.
There's something that requires them to do something, to take some stance, to basically do something that would violate their beliefs or require them to undermine those beliefs.
Right.
So students are not, they're receiving information. They're not being forced to share or discuss things that may violate their family's religious beliefs, because that, gets us closer to that line that might constitute a burden at that point.
Right.
And then the court kind of wraps that discussion up with this conversation about democratic governance of schools. And because it becomes this issue of if we did allow parents to opt out of these curricular choices, that creates this problem where we've got kind of individual preferences overcoming the results of
the democratic process.
Exactly.
Like you said before about, we've got these processes in place. You want, you can elect board members, right? You can make your voices heard at school board meetings. It's like we have created a democratic process for you to be involved in.
Right.
If you would like to help shape our schools and shape our curriculum, there is a democratic process for that. And as soon as we start carving out all of these sort of exceptions to that process, then we have essentially taken the teeth out of that process, or, I don't know a better way to say it.
Right.
Like cut it off at the knees.
Exactly. Yeah. It becomes it's no longer a kind of like community consensus. It's kind of an everybody for themselves sort of thing. And the court succinctly says, the free exercise clause affords an individual protection from certain forms of governmental compulsion. It does not afford an individual a right to dictate the conduct of the government's internal procedures.
Oh boy.
And so like, it's basically saying like, yes, you have your religious freedoms, but your religious freedoms don't necessarily give you the authority to tell the government what to do. And so it becomes this really challenging balance between individual liberties and the democratic process.
Man, Chris, this stuff is like fascinating.
Oh, and trying to figure out where these lines are or how to balance all of these interests.
Right.
Like, and especially looking at the substantive due process claim, like the parental rights claim. Now you've got religious liberties, you've got parental rights, you've got children's rights, you've got governmental authority, like all of it gets tossed together, and the court having to navigate all of these interests, which have constitutionally significant interests.
Sure.
Like, I don't envy courts who have to deal with this stuff.
No. It's nice to just be sitting here on this podcast talking about it.
Right. Yeah. It is a ton of fun. Right. But so for the substantive due process claim, the court kind of looks at this in the same way and says, parents do have this fundamental right, but we have to be really careful about how we define this right.
Mm-hmm.
So fundamental rights are those rights that are just kind of like objectively deeply rooted in our nation's history and tradition.
Mm-hmm.
And so in order to kind of like articulate those, we have to be really specific about what it is that we're trying to protect, because over-generalizations become really dangerous then. And so they say there's kind of two ways to articulate the right here. It could be the right to raise your child unrelated to any religious upbringing, or a potential different way to say it is it could be the right to raise your child within your religious faith. And there's a long history of court cases that kind of recognize parental rights to direct the care, custody, and control of their children. These go all the way back to things like Meyer versus Nebraska, which I think we've mentioned before, from 1923, Pierce versus Society of Sisters in 1925. But the way we define the right is really important, because while parents have the right to control the education of their child and to direct their upbringing, the existence of that right doesn't necessarily require the application of strict scrutiny every time parents assert authority over a child's education.
Essentially what they're saying is they have a right, but that right doesn't guarantee you all of this control
right?
For every single time you want to exercise that right.
Right.
There's not going to be a hearing and a this and a that every single time.
Yeah. So similar to what the court said earlier, like they say parents may have a fundamental right to decide whether to send their child to a public school, but they do not have a fundamental right generally to direct how a public school teaches their child, because those things are kind of given over to the democratic process.
To the state.
And to the state.
Yeah.
And so, we've got that religious question in there too. And the court kind of looks at that and says like, this is kind of maybe a closer question, because now we've got parental rights and religious liberties at the same time. So there's kind of this potential like hybrid claim where you put these two together to make a stronger claim. And the court kind of dismisses that, though. This is something we talked about in Kennedy, when the majority opinion says the teacher or the coach's speech was doubly protected by the free exercise clause and the free speech clause. Here is another case where we've got two potential concerns of constitutional significance. So maybe if we put them together, we get something stronger. The court here rejects that and says like, we're not going to take two unsuccessful claims, put them together to make a super claim.
Yeah.
And so they apply rational basis and they say, the law survives rational basis review because the no opt-out policy serves the board's legitimate interest in kind of its efforts of fostering a culturally inclusive curriculum, of kind of, realizing those articulated goals that the district really put front and center.
Yeah.
And they say like, yeah, the curriculum does that. Those are legitimate goals that the school can pursue. So we're not going to touch the no opt-out policy. And for those reasons, the court denies the preliminary injunction and the case moves forward.
Yeah. So this is going to be a really interesting one to follow, right? And we said it before, like this is why we picked this case, is because it's dealing with, it's sort of representative of so much of what is going on out there
right
in our schools and our communities. And so it's going to be very interesting to follow this one and see where it goes. Because again, like you said, while it did make some state claims, the big claims here are federal, which means when the courts do wrestle with these claims, it's going to be very important for everybody in the country to pay attention to how these courts wrestle with these particular issues, right?
Right. And this is going to be an ongoing conversation in the courts.
Right. So one of my big thoughts about this that I feel it's kind of important to mention is that I think these conversations often take place on the fringes, right? So on the extremes, regardless of what position that you might take on diversity, inclusion, LGBTQ issues, whatever. What's out there moving the conversation seems to be at these sort of polar extremes, right? But my point is that I think that one of the things that is so often lost in these conversations that this case illustrates is the complex, highly nuanced, and deeply personal nature of these topics, right? Regardless of what sort of side of the equation you fall on. And they can't, that complexity and that nuance, right? And that deeply personal nature, those things can't be ignored. And they can't be blindly or uncritically implemented either. And I think this is where teachers and administrators live, for better or worse, right?
Right.
They don't live on the fringes where these talking heads on the news programs live. They live in the middle of the muck. What I hope, no matter where you may fall on this particular issue, what I hope this case has revealed is that this stuff is really, really hard to navigate where the rubber actually meets the road, which is in schools.
Right.
Right?
Mm-hmm.
So, let's recognize that and give our teachers and our administrators a little bit more love and respect for day in and day out doing the impossible work of trying to thread these needles. I have never met a teacher that has tried to intentionally indoctrinate kids one way or the other.
Right.
Okay. Now, that isn't to say that some don't exist.
Mm-hmm.
We all have values that we care about. And yes, those values get communicated. My point is that I think that the vast, vast majority of those people working in our schools are there not to teach kids what to think, but to teach them how to think.
Mm-hmm.
They're there because they love children. They're obviously not there for the money. They're not there for the
Wait, what?
For the easy workload. They're not there for the constant criticism.
Mm-hmm.
They're not there for the often unrealistic expectations that are placed on them. They're there because they want to do right by their kids.
Mm-hmm.
That's the vast majority of the people who work in the schools.
Mm-hmm.
And what they need is they need us to recognize that they're the ones who are being asked to make all of this muck clear. And they need our help and they need our support. They don't need to be the pawns in some kind of culture war.
Mm-hmm.
And
Yeah.
I just think that this case really illustrates how difficult this is
Right.
for the people who actually have to do the work here.
Right. Who have to navigate these interpersonal,
Yeah,
relationships, right? Like, 'cause
totally.
so much of the story in this case is kind of one of maybe building community trust, community outreach, and like really kind of navigating these relationships in productive ways, because that, it's exactly right. Like, these teachers are kind of caught between a rock and a hard place. Like,
Yeah,
they're trying to do what the district says, and then they're caught in these political winds and trying to navigate too, like, making sure all their students feel respected and valued and understand kind of the larger, what's going on in this bigger picture. Like, all of that stuff comes, and then we have these teachers who, like you said, are kind of forced to navigate this really tricky situation, which just shows that, like, a lot of the law comes back to relationships.
totally.
Is there more they could have done to kind of lean on and build and develop those relationships in caring, productive ways? Maybe that wouldn't have stopped a lawsuit. Probably wouldn't have in this case, just given kind of the deeply held nature of a lot of this stuff. But, it goes a long way to smoothing out the edges.
Yeah, no, I completely agree. And this is hard stuff. And listen, I just feel like it's really important to stress that so much of this conversation is, I think what we hear of this conversation lives on the extremes.
Mm-hmm.
And what our teachers and our administrators are dealing with, it's not there.
Right.
Where the rubber meets the road, it's messy, it's hard, and they're doing the best they possibly can to do right by their kids, all of their kids.
Right. Yeah. And we only hear about the places where, and especially when you're just talking about lawsuits, right? Like,
Yeah,
nobody files a lawsuit when everything's going well.
right.
In the vast majority of situations, everything's going well and nobody's filing a lawsuit, right?
Yeah. So you teachers and administrators out there, you're rock stars in our eyes. So keep up the good work. And yeah, I mean, I think that's probably a good place to leave it. We'll keep you posted on how this goes. I'm sure we will be circling back to this case, folks.
Yeah. Yeah. The denial of a PI is a kind of a big deal. So
No, that's big. That's big. All right, Chris, give us our homework.
your homework, if you choose to accept it, is to find Chalk and Gavel wherever you get your podcasts, like, rate, review, and subscribe. If you can leave a review, that's such a huge help, because that is one of the best ways to get us out there in front of more people. You can also go to chalkandgavel.com, fill out our survey for feedback. We'd love to hear your thoughts, comments on social media as well. Hit us up at Chalk and Gavel. If you've got ideas for cases or bell ringers or whatever it might be, if there's topics that you're following that you want us to talk about, let us know. We'd love to hear from you. Keep the conversation going.
Absolutely. Absolutely. Well, that does it for today's episode of Chalk and Gavel, folks. Thank you so much for listening. I am Jamie Cudlitz.
And I'm still Chris Thomas.
We'll see you again in a couple of weeks when we continue to explore how the courtroom is connected to the classroom.